Have you ever noticed how some public issues are widely acknowledged, officially documented, and yet still strangely difficult to follow? It's not always about hidden secrets or grand conspiracies. Sometimes the sheer volume of official processes, the layering of legal steps, the gradual unfolding of information through regulatory channels, and the deliberate pace of institutional communication can make even well-trodden ground feel complex, and in its own way, unresolved. Today, we're going to slowly unpack one of the most publicly discussed processes in the United States, and yet one that remains procedurally difficult to trace. We'll delve into the extensive institutional response surrounding the Boeing 737 MAX aircraft. This isn't a story of uncovering new evidence, but rather one of observing how various layers of government, regulatory bodies, and corporate entities over years have attempted to understand, explain, and address a series of events, leaving a trail of documents, testimonies, and legal actions that reveal a deeply intricate procedural landscape. The issue first seized global attention in late 2018 and early 2019, following two catastrophic accidents involving the 737 MAX aircraft. Lion Air Flight 610 in October 2018 and Ethiopian Airlines Flight 302 in March 2019. These events, occurring within 5 months of each other, immediately triggered a sequence of institutional responses. Initially, various national aviation authorities, including the Federal Aviation Administration, FAA in the United States, issued emergency airworthiness directives, and subsequently an unprecedented worldwide grounding of the aircraft type. This grounding, a significant procedural step, marked the beginning of a prolonged period of intense scrutiny. From that point, the official communication began to develop gradually. The FAA, as the primary certifying authority, found itself at the center of this burgeoning procedural narrative. Its initial statements focused on working with Boeing to understand the cause, referencing ongoing investigations and a commitment to safety. The National Transportation Safety Board, NTSB, and International Accident Investigation Boards from Indonesia and Ethiopia commenced their painstaking work, each operating under specific protocols to collect data, analyze flight recorders, and interview personnel. Their preliminary findings, released through formal reports and press conferences, slowly introduced the public to technical terms like the Maneuvering Characteristics Augmentation System, or MCAS, a flight control software feature that became central to the investigations. As these technical details emerged, the procedural story deepened. Congress, exercising its oversight function, initiated a series of hearings. These weren't singular events, but rather a progression of testimonies before committees such as the House Transportation and Infrastructure Committee and the Senate Commerce, Science, and Transportation Committee. Through these hearings, the public almost received clarity. Lawmakers questioned FAA officials and Boeing executives, probing the original certification process, the relationship between the regulator and the manufacturer, and the internal communications that preceded the accidents. Transcripts and video recordings of these sessions became public records, offering glimpses into internal decision-making at Boeing and the FAA's oversight mechanisms. Each hearing, while intended to shed light, simultaneously revealed the sheer complexity of certifying modern aircraft, the reliance on self-reporting by manufacturers, and the challenge of overseeing highly technical systems. The narrative was no longer just about a faulty system, but about the intricate procedural ecosystem within which that system was designed, approved, and operated. The regulatory language, too, began to evolve. The FAA moved from emergency directives to more comprehensive orders detailing specific software updates, new training requirements, and revised maintenance procedures. These documents, written in precise regulatory prose, detailed the steps necessary for the MAX to eventually return to service. International regulators, such as EASA in Europe and Transport Canada, conducted their own independent reviews, often imposing additional requirements beyond those mandated by the FAA. This divergence in requirements, while ultimately aimed at safety, illustrated the fragmented nature of global aviation oversight, where harmonization is a goal, but national procedural autonomy remains paramount. Then a new institutional actor entered the public frame, the Department of Justice, DOJ. In January 2021, the DOJ announced a Deferred Prosecution Agreement, DPA, with Boeing. This was a critical legal step, revealing a different facet of the institutional response. The DPA, a multi-page legal document, laid out the government's findings that Boeing had engaged in a conspiracy to defraud the United States by allegedly concealing information about the MCAS system from the FAA during the certification process. The DPA imposed a financial penalty of over $2.5 billion, including a criminal monetary penalty, compensation for airline customers, and a fund for the crash victims' families. When this DPA was released, the public once again almost received a definitive resolution. Here was a formal accusation, an acknowledgement of wrongdoing by the corporation, and a significant financial penalty. Yet the DPA itself, while detailing specific acts of concealment by two former Boeing technical pilots, carefully avoided assigning blame beyond a corporate level, describing a culture where certain employees chose the path of deception. It outlined compliance obligations for Boeing, requiring the company to report to the DOJ on its internal ethics and safety programs. But even with this comprehensive legal filing, the minute-by-minute procedural interactions, the precise sequence of decisions, and the full scope of internal knowledge during the initial certification remained, in many ways, an ongoing subject of inquiry. The DPA offered a legal conclusion to a specific charge, but the broader institutional story of how such a procedural lapse occurred within the regulatory framework continued to unfold. The families of the victims, through their persistent advocacy, also brought new procedural dimensions to light. They challenged aspects of the DPA, specifically arguing that they were not properly consulted as victims under the Crime Victims' Rights Act. This legal intervention led to further court proceedings, and ultimately, a federal judge ruled that the DPA had indeed violated the rights of the victims. This judicial finding did not undo the DPA, but it added another layer to the complex legal history, highlighting how even established legal agreements can be procedurally challenged and refined through subsequent court actions, long after their initial announcement. Meanwhile, the process of returning the 737 MAX to service continued, country by country. Each step required the FAA to issue new airworthiness directives, conduct flight tests, and approve revised training programs. This recertification process involved hundreds of thousands of hours of work, countless documents exchanged, and numerous technical reviews. Each time the FAA made a new pronouncement or another nation lifted its grounding order, it felt like a marker of progress, a step towards normalcy. But for those following the procedural details, each such announcement also contained references to ongoing monitoring, future audits, and the continuing development of enhanced safety measures, indicating that the institutional process wasn't simply ending, but evolving. Even today, years after the accidents, after the grounding, after the congressional hearings, after the DPA, and after the aircraft's return to service, the full procedural story remains a dynamic landscape. There are ongoing congressional oversight requests, continued internal compliance reviews within Boeing, and public discussions about the future of aviation regulation. The Department of Transportation's Inspector General continues to release reports examining aspects of the FAA's oversight. These documents, though often highly technical, contribute to a gradually accumulating body of institutional knowledge, each piece clarifying one aspect while simultaneously revealing how much more remains to be precisely documented and understood within the intricate dance of regulatory compliance and corporate operation. This long-running procedural story of the Boeing 737 MAX illustrates a fundamental characteristic of U.S. institutional processes. They are rarely swift or singularly conclusive. Instead, they unfold in layers. Initial public awareness, emergency regulatory actions, detailed technical investigations, legislative oversight, criminal justice interventions, civil litigation, and continuous regulatory monitoring. Each step, though distinct, interacts with the others, shaping the narrative and producing a vast, often fragmented public record. The journey from crisis to resolution, or perhaps more accurately to ongoing management, is paved with official statements, court filings, congressional testimony, and complex regulatory language that, even when accessible, demands careful, patient deciphering. Maybe that's what makes these stories worth returning to. We'll continue exploring them together. I'll see you in the next video.